What happens to your patents and trademarks when you die? You spend years, effort, and serious money, often tens of thousands of dollars, to create a valuable intellectual property empire. You secure those priceless patents, register those robust trademarks, protect your valuable copyrights, and lock down those precious trade secrets. You've built an IP asset portfolio designed to generate income for years, even decades. But here is the true terror. When you're gone, does that empire continue to generate value for your heirs or business partners, or does it become a worthless liability? We're talking about the true terror of poor planning. Hello, and welcome back to Spellbinding IP, Patent, Trademark, and Business Strategy, the show that helps you build a brand so strong it survives its own sequel. The thesis today is simple yet alarming. A standard will and skimpy business operation documents can be a death sentence for your most valuable intellectual property. If you haven't taken specific legal steps to address the unique life cycle of your patents and trademarks, your competitors could inherit them before your family or business does. Let's dive in to how intellectual property can end up in the legal graveyard and how you can prevent that. Most people think of their IP like a regular asset that upon their death will either transfer automatically or be handled easily by the executor of their estate. But IP is different. IP is a tricky beast. The biggest, most terrifying difference is this. Patents and trademarks are time-sensitive living assets that require active maintenance and use to survive, and special documents to transfer ownership. A patent is a 20-year legal monopoly. Renewal fees are due 3 times during those 20 years. If your executor doesn't know the exact schedule and misses one maintenance fee payment, that patent is permanently dead and immediately enters the public domain. The clock is heartless. It does not stop for probate, and ignorance is no defense. A trademark can be perpetual, but only if it's used, and a registration's lifespan depends both on use and filing renewal documents along with fees. If your heir inherits the mark but fails to continue using it in commerce for the goods and services listed, the law presumes the mark has been abandoned, and if they don't file the renewal documents and pay the fees, the USPTO will cancel the registration. Let's look at the specific risks of poor intellectual property succession planning. These are the ghosts of your assets that haunt your legacy if you fail to plan properly. First is the patent ghost, missing the clock. The executor of your estate is managing property taxes, house sales, and who gets the valuable coin collection. They are most likely not automatically tracking USPTO patent maintenance fee deadlines, which occur at the 4th, 8th, and 12th year. If those deadlines are missed, the patent is dead and its value is zero. If the executor fails to file the proper ownership transfer documents, the legal right to its benefits remain in purgatory. Second is the trademark ghost, competitor capture. Your heirs might be grieving and not well versed in handling a trademark. If they fail to file the necessary maintenance and renewal documents showing continued use in commerce, the USPTO will cancel the registration, and if the mark hasn't been used in commerce for at least the last 3 years, your biggest competitor can simply step in and register the abandoned mark. Third is the trade secret ghost. This one is the fastest killer. If the documents securing your trade secrets, like non-disclosure agreements or internal protocols, are not enforced by the executor, or if they don't even know where they are, the trade secret can be compromised or simply lost. Either way means its value is lost forever. Finally, we have the business ghost. If you own the patent or trademark as an individual, license it to your business as an LLC or corporation, because you are doing that and you're not being sloppy about that kind of important business asset, right? And you only address the IP in your will, you create massive confusion. If an heir who doesn't know how to maintain the IP properly or who hates your business partners gets your IP, your business will have a serious problem. Without clear documents, the business often gets tied up in court for years. So why is the standard will, drafted by a general attorney or an estate planning attorney not well versed in intellectual property, insufficient to properly transfer patent and trademark ownership? It comes down to three legal concepts. First, bequest versus assignment. A will can bequeath or give property, but patent, registered trademark, and registered copyright transfer require a specific assignment document filed with the USPTO or the Copyright Office. Without the specific authority granted to the executor or a named successor to file that document, the transfer can be delayed or rejected. Worse, if the executor or heir doesn't know the assignment document needs to be filed, the ownership is stuck in legal limbo. Second is an LLC operating agreement or a partnership agreement or corporation bylaws. These are the documents that truly dictate the fate of a business. If the IP is owned by the business, like an LLC, the operating agreement dictates what happens with the IP upon your death. Specifically, it determines who inherits your share of the company and its assets. The will cannot override that operating agreement. If that agreement is silent, however, your heirs could be forced into a partnership with people they don't know, or worse, the business could be legally dissolved. These principles apply to partnership agreements and corporation bylaws as well. Third is the license. If you own the IP personally and license it to your business or another business, who inherits the rights to the IP when you die? Does the license provide that your heirs inherit it? Does it say the management of renewals transfers to the licensee and your heir just receives the royalties? Or does it state that the IP ownership will transfer to the licensee? If your license rights go to your heirs, will they know how to manage the IP properly, and will they be willing to renew the license as needed? The license needs to address these issues so the IP ends up in the right hands. You don't need to fear the true terror of poor planning of intellectual property succession because you can and you should plan to avoid it. If you have high-value trademarks or patents, here are your immediate next steps, the only way to truly protect your legacy. Action 1. Take an IP inventory. Create a detailed, organized inventory listing every registration number, filing date, and maintenance schedule for every IP asset. Also include details identifying any unregistered assets. Give this to your lawyer and your estate executor. Action 2. Check your LLC operating agreement. Immediately review this document for specific clauses covering the death or incapacity of a member. These clauses dictate the fate of the company and, by extension, its IP assets. This goes for partnership agreements and corporation bylaws as well. Action 3 is consult the right lawyer. Schedule a consultation with an attorney who handles both intellectual property protection and business succession planning. You need an attorney who sees your assets not just as legal filings, but as high-value, lifelong components of your estate. If they're not well-versed in estate planning, have them work with the attorney handling your primary estate planning needs. If you're serious about protecting the assets you've worked so hard for, don't let the true terror of poor planning define your legacy. I'm Julie King, the rock and horror-loving patent attorney, and I'm here to help you design around your biggest legal fears. I'll dive into the specifics of those LLC agreements and succession plans in future episodes, so stay tuned for the sequels. Intellectual property is one of the most terrifyingly useful tools you have. If you're a creator or other entrepreneur ready to build a frighteningly powerful brand and business, you need to know how to use it. But you don't have to face the darkness alone. To learn more about protecting your creations, your name, your business, and your legacy, you can book a consultation with me at kingpatentlaw.com. I'm Julie King, a licensed attorney in Champaign-Urbana, Illinois, and I help entrepreneurs across the U.S. make smart, legally sound decisions about their intellectual property. If this episode helped you survive the horror of learning about how to protect and manage your intellectual property and business, please like and subscribe if you haven't already. You can find all of my other frighteningly good content at the King Patent Law website, at Spellbinding IP, Patent, Trademark, and Business Strategy on all major podcast platforms, and at King Patent Law on most social media. The information provided in this episode is for educational purposes only and does not constitute legal advice or form an attorney-client relationship. You should not act on any information presented here without first seeking the counsel of a licensed attorney, perhaps me, for your specific legal needs. Thank you for tuning in. Stay legally sharp and keep rocking your IP.